Okay, welcome everyone to our Accommodating Disabilities in the School Meals program. And this also encompasses the child and adult care food programs. I'm Dana Parker, the Director of Training for Child Nutrition Programs here at the State Department. And we've kind of gone over, but we'll say it again. If you have a question, please type it in the little chat box, if you can find that on your computer. We'll try to answer the questions at the end of the presentation. However, if we don't get them all answered, we do get a list of those questions and we will try to answer those and send those out to the participants. Also, we're going to put this webinar, as we are recording it, we will put it on CARS and the CFP website in a few days. So let's get started. An introduction to our presentation today comes from our National School Lunch Program and Breakfast Program, because we want to aim to provide all children with nutritious meals regardless of their disabilities or backgrounds. And also, as a school food authority or a child care center, you must comply with the USDA regulation, because we want to make sure we benefit all of our participants in the schools. In a 2010 USDA census, there's about 2.8 million children, school-age children, who are disabled and participate in the school meal programs. Some of our civil rights program authorities, as you can see on the screen, they cover a multitude of acts and amendments. Most of the amendment we're going to be talking about today is the American Disability Act Amendment of 2008, but it also encompasses many more statutes. And if you look on the screen, here is another slide with more government regulations in our Department of Child Nutrition. The memo guidance that we have looked at and researched for this presentation comes from the Memo SP 59-2016, which basically states that schools must accommodate disabilities in the meal program, and it also replaces our FNS instruction 783-2, revision to meal substitutions for medical and other special dietary needs. And here in our Americans for Disability Act Amendment of 2008, the main point is that the Disability Act states that you must make reasonable accommodation for children in your district or in your center that are considered disabled. This memo has also expanded the definition of disability, and it makes it very clear that the emphasis must be on providing a reasonable modification and not placing a high burden on the disabled person to prove that he or she is disabled in some way. This amendment also better aligns with the congressional intent to incorporate that the amendment, the terms of the disability in the American Disabilities Act. And it also states that the SFAs and centers should work with the families to ensure a child with the disabilities have equal opportunity in our programs. But however, schools or centers should not engage in weighing medical evidence against legal requirements to determine if a medical or physical condition meets the definition of disability. And what that basically means is you're not the one that's going to make the decision if a child has a disability or meets the definition of disabled. That will be from a doctor's statement, a 504 plan, or an IEP. And in the amendment of the 2008, it basically states that most physical and mental impairments constitutes a disability. From our memo in the booklet from FNS, Accommodating Children with Disabilities in the School Meal Program, and that's the website on the screen that you see. This booklet answers has several questions and answers. Some we will be looking at today, and some are there that you may want to go reference in a situation that you may have at your school. Some of the major life activities that are considered a disability that impacts our everyday life, such as seeing, hearing, walking, speaking, learning, reading, eating, and breathing. Some of the other major life activities that constitute a disability are major bodily functions, digestive, immune system, respiratory, circulatory, neurological, and brain. In our PowerPoint today, if you see scenario 1, in the booklet that I mentioned earlier, there are several scenarios that bring out some real life situations. So let's read the question on the screen. A child with autism is very sensitive to food textures and will only eat foods with a smooth texture. Is this child's condition considered a disability? And if so, must the school food service authority or a child care center make a modification for the child? So we're going to look at if that child has a disability and do you have to make the recommended changes for the meal plan. Our answer is yes, because according to the American Disability Act, any physical or mental impairment impacting a major life activity such as eating could be considered a disability. And some children with autism do have sensory sensitivities, and they prefer a certain texture of foods, and they may prefer a certain color. So therefore, that child with autism may need reasonable modifications. What is a reasonable modification? It's a change or alteration in your policy, practice, or procedures to accommodate a student or a child with a disability. Your duty is to negotiate over the modification. This means simply saying no to a dietary modification is almost never appropriate. In other words, if a parent comes to you and states that their child needs a special meal and has a doctor's statement, it is almost never appropriate for you to not accommodate this special needs child. However, you must do this on a case-by-case basis because every situation is different. Should the modification provided should be related to the disability or the limitations caused by the disability. Does not have to be the modification requested. In other words, if the parent wants you to only buy a certain brand of milk, as long as the milk meets the requirements, you do not have to buy the brand name, unless, of course, the medical statement states there is a brand name involved. And it should generally be free of charge to the student, and it should be implemented even where the person requesting the modification believes more should be done. So if that parent believes that brand name product should be bought, you may not have to necessarily provide the brand name product. You also must consider the cost and the resources available, the participant's age and ability. We are never to stereotype a certain condition. That cannot drive our decision on how we're going to base our modification. The meal modification does not have to be the exact mirror of the meal that you're providing to the rest of the students. And a life choice, such as being a vegetarian, are not considered a disability and do not need to be accommodated unless it is related to a disability. Now let's look at our next scenario. Question: the regular menu for lunch at a local middle school is whole grain rich pasta with cheese, a vegetable topping. Must the school food service director prepare whole grain rich pasta with lactose-free cheese and vegetable toppings for a child with a lactose intolerance? And if you remember our previous slide, we said it doesn't have to mirror the exact menu, so no. In a situation such as this, the meal modification or the substitute does not have to mirror the exact menu offered that day, but it is the SFA or the center's responsibility to serve the child a safe meal that accommodates their disability. In other words, if instead of maybe substituting the lactose-free cheese for that student, they may make a whole different entree for that child. They may make the hamburger and french fries instead of the, say, macaroni and cheese. So in this example that we used, like I said, they would not have to use the whole grain rich pasta. Instead, they could use a different meal which meets the modification. What are some fundamental alterations? Exceptions, modifications are not required that would fundamentally alter the nature of the program. If an SFA declines a request, the SFA or School Food Authority must have some procedural safeguards to ensure that the child's parents or guardians understand their rights for the disability. And the parents have a right to file a grievance if they believe that there has been a violation that's occurred when they've requested a reasonable modification. They should receive prompt and equitable resolution of the grievance, request and participate in an impartial hearing to resolve the grievance, be represented by counsel if they choose at the hearing. They are allowed to examine the record and receive a notice of the final decision and a procedure for review. And they also have the right to appeal that decision. Again, I would emphasize if the SFA feels they are not capable of making a meal modification, that they should contact the State Department of Education, Child Nutrition, or at a minimum consult their consultant in their area for further assistance. Do not take it upon yourself just to deny a modification because you feel that your program may be altered or not have the funds to accommodate a special dietary needs student. In other words, denying a modification under the fundamental alteration exception should not result in the denial of access to service. And before making that decision, please contact us here at the state office. Now let's look at our scenario again. A number of children at a high school receive modified meals due to a disability. The SFA has a medical statement on file supporting all of the modified meals. Is this school food authority eligible to receive the additional 6-cent reimbursement for compliance with the meal program? And I'll explain a little bit about the 6 cents, so we may have some participants on that are from our child and adult care food programs. In the school meal program, if a school district is meeting the meal pattern requirements, USDA pays them an extra 6-cent reimbursement on all lunches served throughout the day. So these children, it appears they all have medical statements. So are we going to allow those school districts to claim that extra 6 cents, even though these meals weren't technically reimbursable? The answer to that is yes, because these meals were modified due to a disability, so they are eligible to meet the 6-cent reimbursement. And truthfully, with that scenario, that would mean those meals are reimbursable to meet all the reimbursement. And those children would be carried in whatever categorical eligibility they were currently receiving. If they were in a CEP school, community eligible school, a provision school, then of course their meal would be given to them at no charge. If they were in a regular accounting and claiming school, whatever category, free, reduced, and full paid, you would claim them in those category and charge accordingly to their status of paid or reduced if they did not fall under the free category. Some of our major food allergens that we want to look at, because even having a food allergy does constitute a need for a alternative meal in some schools. So I'm going to try to click on this link. It takes us out to the FDA website, and it says I have an error. Okay, we can't click on the website, but it is a great website to go look at and garner some more information on different food allergies that may be present in your schools. Some of our major food allergens that you see on the screen, peanuts. I think peanuts is one that's very well known. Milk, eggs, wheat, soy, tree nuts, fish, crustaceans, and ingredients containing protein derived from one of the 8 allergens listed above. Okay, hang on, we're not changing screens. Hold with us just a moment. Okay, now it's trying to go to the website.
Maybe looking for your other website.
It's looking for our website. If everyone just hang on just 1 second. All right, there we are.
Back you up a little. Can you talk about that still?
I can.
Okay.
Yes, we're still on the food allergens. So on this website, as you see, it's from the U.S. Food and Drug Administration. If you have questions on a major thing to do if you have a child with a food allergy, this would be a good resource to have saved on your computer to go in and research what that allergen could be and some alternative products for those children, to be able to offer them things in your child nutrition meal pattern services to accommodate them in the lunchroom, because we don't want to just feed the students the same meal every day.
Let me try hitting over here. We'll make it wake up here. There you go.
There we go. Thank you, Gary. Our handy technical person that knows way more than I do. We appreciate his services. We're going to talk a little bit about, because I've mentioned a 504 plan, an IEP. So let's talk about those just a little bit more. Federal civil rights legislation, including Section 504 of the Rehabilitation Act of 1973, IDEA, and Titles 2 and 3 of the Americans for Disability Act requires that SFAs must ensure children with disabilities participate along with children without disabilities to the maximum extent possible. This allows the children to interact with other children and learn from them during the lunch meal services. Schools and centers, however, may isolate eating areas for children with some severe allergies, such as peanut allergies. Some schools do have a separate table or room for that child to eat if they know that peanut allergy is severe. But children cannot be segregated with a disability just due to convenience. In other words, because the aide or the principal or whomever decides that child is disruptive at lunch, we're going to put them in a room by themselves every day, that could be constituted a civil rights violation. So you really would want to watch when making determinations on segregating the disabled students away from the regular students. And the overall message that we want to give during this presentation is one that the school, the center must communicate with the parents or the guardians and have a two-way communication so that you guys are all on the same page, because we want to be a balance between safety and a stigma. If the child is getting put in the room, that is not good for their person, and we want to make sure we are following the civil rights regulations. And the accessibility of the program, we want to ensure that our lunchrooms are accessible to our children with disabilities. We may need to provide some auxiliary aids and services, maybe a person to aid them. Maybe we need to buy handicap ramps to replace the stairs. Maybe it's some adaptive feeding equipment, some tracking assistance because we need to track what they're eating. All of these methods are allowable, and they are allowable cost to the child nutrition program. If your child nutrition program is running tight with funds, there are other funding sources that can be used from your special needs account for students with disabilities. So there's other ways you can go to provide funding. Now let's look at another scenario. A large number of children in an elementary school or center have peanut allergies. Should this organization go peanut free? And I have seen several schools that do say they're peanut free. I know in daycares they tend to try to be daycare or peanut free. But do you have to go peanut free? And the answer is universal exclusion of a specific food or food groups is not a Food and Nutrition Services policy. In other words, it's not a USDA policy, but it could be appropriate for your circumstances if you choose to do that. Just be very careful that in advertising and letting parents know that you are a peanut-free or allergen-free on the basis, no peanuts in your district, that your school really does implement the policy and everyone is aware so that they know that their children are in a safe place. It's probably very hard to guarantee no one brings any peanuts from home in a sack lunch. That's where I think schools have seen that happen. They try to be a peanut-free district. However, it's hard when parents are allowed to bring in lunches for their children. Organizations should develop some procedures to address requests to accommodate students with disabilities. And in developing these policies, a school district or even a daycare center might put together some type of team, because you want to look at what the 504 of the Rehabilitation Act of the 73, the IDEA, to fulfill these requirements to have procedural safeguards for meal modification. And like I said, the best practice is to form a team, implement the guidelines. And when you're implementing this team, that team could be the school nurse, the cafeteria director, manager, the teacher, because we want to keep our children safe and what is best for that child. So we want to make sure we involve those parents, the guardians, to keep everyone safe. Sorry about that, I rolled instead of clicked. For some of the disabilities, USDA prohibits the following discriminatory actions. You cannot deny a person with a disability the opportunity to participate in benefits without aids or benefits of the service. You cannot provide a person with a disability, or you should provide a person with a disability an opportunity to participate that is not equal to the opportunity that the others have. In other words, if you can't discriminate and say, well, you have disabilities, so we're going to only give you bread and water and everyone else gets a meal. You can't deny a person with a disability an aid or a benefit or a service that is not effective as the aid, benefit, or service provided to others. So you can't make a difference in those children. You need to treat them each on a case-by-case basis, but you can't give to one because maybe their parents have more or less than the others. Provide a person with a disability a different aid, benefit, or service unless doing so is necessary to provide an aid, benefit, or service that is effective as those provided to others. We've mentioned the medical statement a couple times. Medical statements are required when the meal modification does not meet the meal pattern requirements. And that has to be on a doctors, from a well, I shouldn't say doctor, it has to be from a medical professional. It should include information about the child's physical or mental impairment to help the SFA understand how it restricts the child's diet. It does not necessarily have to have the diagnosis on the request, and you should not ever request the diagnosis. You just need to know how it restricts the diet and how you are to accommodate the condition. You need to know what must be done, what foods that should be served, and what foods should be omitted in the cases of the meal modification. And what I would suggest here is if you receive a medical statement from a licensed practitioner, and it just basically says Junior cannot have eggs, you may need more information to know what you could possibly substitute for eggs. Or if it's strawberries, maybe they need to say, they're allergic to strawberries, but they can have all other fruits. You want to have your medical statements as clear and easy to follow as possible from the medical authorities. Understanding the medical statements, they come in from a wide variety of medical practitioners, so you must work closely with your 504 coordinator and your school nurse and the parent. I would also add the parent in here. So if that medical statement is unclear, that you are already in communication with that parent, because you do not want to delay that meal modification, because it could be a safety issue for that child. It could be a matter of life and death. So you want to follow that portion that is clear on that medical statement and try to provide some clarifications so you are well aware of what the medical statement needs to say and what you need to follow. We mentioned a little bit ago about a brand name. If a medical statement of a meal modification requests a brand name, then it is your responsibility to purchase that brand name product. However, if the medical statement does not indicate a brand name item, and the parent or guardian just says, well, they only eat XYZ product. Well, and XYZ is 3 times the cost of what the generic brand would be. You are not responsible for buying the brand name product only because that's the only one they will eat, unless the doctor's statement says it's medically necessary that they have that specific brand name product. When we're talking about offer versus serve, in the school meals, of course, the child and adult care food services cannot or do not have offer versus serve. Children with meal modifications must have the option to select all the components that are available to the other children. An SFA cannot just basically say, oh, if you are allergic to milk, and we're offer versus serve, and you have to take 3 of the 5 items at lunch, just don't pick up your milk. That is not appropriate. That is a civil rights violation, because you cannot exclude a food component or an item in the meal program because of the disability. I would, however, say if we go back to the vegan example, that the child wanted exclude a food item because they are vegan, that would be one example. You could explain to the parent or guardian and or the child that if they're wanting to choose a vegan meal, they could simply not select the meat offering that day, because they do have to have the 3 of the 5 items at lunch. So they could decline the meat component and would still have the reimbursable meal. When talking about procurement of the special meals or having meals with disabilities served in your school, if you're contracting with a food service management company, the management company should always keep in mind that that is a part of the meal program, and they have to accommodate students with special dietary needs. If at all possible, a school, when going out for bid, as we say in the food service, they should include any meal modifications that the FSMC, the Food Service Management Company, are going to be dealing with. A school district might also include in their contract that this is a possibility, and a food service management company will be responsible for feeding those children and not garnering any extra money from the school food authority based on those meal modifications. Because in turn, the State Department does not offer any additional reimbursement for meals from disabled students. So therefore, a school district would not be required to pay a management company more for a meal that was for a disabled student. Do we have any questions? I haven't really seen any questions pop up at this time, but we will stay online for just a few more minutes and see if there are any questions. If not, the presentation will be posted on the CARS website and under or in the resource library on the Child and Adult Care Food Program. Thank you.